Hello, this is Daniel Lawrence Smith, Associate Director of Training at Out and Equal Workplace Advocates. I'd like to welcome each and every one of you to our June 2015 monthly town call. We now pronounce you what to do with domestic partners. We're here today to discuss domestic partner benefits across the U.S. as we are anxiously anticipating a decision from the Supreme Court of the United States. And with that said, I'd like to welcome our panelists. That's the subject, and we're going to do a brief round of introductions. We'll begin first with Todd, and we'll go left to right, working our way to Bill.
Sure, thank you. This is Todd Solomon. I'm a partner in the Employee Benefits Group of McDermott, Will & Emery, a national law firm. I've done a lot of work over the last 16, 17 years on domestic partner benefits issues when frankly, just a relatively small number of employers were interested in this issue, and it's been great to see over the years how many more employers have been interested. And now, as we'll talk about today, we're at a real crossroads, so I'm excited to be on the call today.
Thank you, Todd. Brian?
I'm Brian Tiemann. I'm also a partner at McDermott, Will & Emery. Thank you, Daniel, for hosting us today, and have been working on issues related to benefits for same-sex spouses and partners since about 2008, and look forward to some good discussion today.
Thank you. Tanya?
Hi, Tanya Moore. I am Vice President and Associate General Counsel for Darden Restaurants, based out of Orlando, Florida, but operating throughout every state with approximately 160,000 employees. This is an issue that is at the core of our business and that's very important to us, so I'm very happy to speak about this today.
Thank you. And last and certainly not least, Bill.
Thank you, Daniel. Yeah, my name is Bill Hendrickson. I'm the Field R&D Leader for our Coastal Crops Business Unit. I'm also the vision element, or what we call the strategic partner, if you will, for equitable policies and practices. And as Tanya already said, Dow Chemical feels like this is also a very critical piece of our attraction and retention, and including LGBT partners.
Thank you, and thank you all for participating today. And so that's just a little bit about who's on the call, but we want to know more about you. So speaking about relationship status, being married or domestic partnered, we'd like you to answer whether you are same-sex married, opposite-sex married, in a same-sex domestic partnership or civil union, opposite-sex domestic partnership or civil union, whether you're single, divorced, widowed. I threw this one in. It's complicated. Or if you prefer not to answer the question, that's fine too. So go ahead and click any or all that apply to you, and then we will give it just a moment or two longer. We're about 50% that have clicked in. Great. And as for myself, I am same-sex married, so I'm going to answer that. And just taking a look. All right, so we've got a little bit in each and every area, so that's good to see who is on the call, just so we can move the conversation forward. Great. Thank you all for your participation. And with that, I'm going to go ahead and turn it over to Brian and Todd for the next part of our presentation.
Sure. Thank you, Daniel. This is Todd. I just wanted to kind of frame the discussion today by setting the stage before we jump into talking about where we are and what the decision points are, to just talk about what an interesting crossroads this is, or what an interesting few years it's been. Obviously, there's been tremendous development in the area of same-sex partner benefits, same-sex spouse benefits, and a huge amount of positive victories, both at the federal level with the Windsor case and at the state level, now being up to 37 states recognizing same-sex marriage. So there's almost always, over the last, say, year and a half, 2 years, pretty much since Windsor, been almost nothing but positive momentum, which makes this conversation kind of interesting, because here's one area where there's some talk swirling and actually
legalize same-sex marriage nationwide by finding that state bans on same-sex marriage are a violation of the Equal Protection Clause, or at least find that all states are required to recognize same-sex marriages in other states where they're legal, and so it would create national recognition then for same-sex marriage as a result of the ruling, based on what's expected, but certainly, that's just a guess, and the court could come out any way opposite as well. But to give you a little bit of context, just to look back to federal law, and talking about the Windsor case that came out in 2013, the Federal Defense of Marriage Act, DOMA, was the law that was at issue in the Windsor case, and it had 3 parts. The first part just set forth the title. Part 3 was the issue in the Windsor case, and that provided that for all purposes of federal law, the word marriage meant only a legal union between one man and one woman as husband and wife, and the word spouse then referred only to someone of the opposite sex. And the Windsor case in 2013 then found that Section 3 of DOMA was unconstitutional, so that it took away the part that limited federal recognition to opposite sex unions. But what the Windsor case didn't do was touch Section 2 of DOMA, which said that, and continues to say that, no state is required to recognize a marriage from another state, so it allows the states to then refuse to recognize other states' same-sex marriages. And in our post-Windsor world that we're in now, what it means is that federal law then defers back to state law definitions of marriage. And obviously with the mix of state laws on this, 37 states now legalize same-sex marriage, but we still have 13 states with either state constitutional amendments or laws banning same-sex marriage. The question has been, what does federal law then defer to in terms of these state laws? And the various regulatory agencies for purposes of employee benefit plans have clarified that what federal law will do is recognize a same-sex marriage that was entered into in any state where the marriage is legal, even if that marriage is not recognized in the couple's state of residence. So this has been sort of referred to as a state of celebration approach. So as long as you're married in a state where it's legal, you'll be recognized for federal employee benefit law purposes, even if your state of residence doesn't recognize your marriage. But I think the critical piece for today's discussion is that what the Windsor case didn't do and what the current cases will not do is provide any federal recognition for unmarried partners. There is no provision under federal law that recognizes, civil unions or domestic partnerships, even if those are unions that are provided for under state laws. And so in the employee benefit context, the various rights and protections that are extended to spouses under federal law, and if we do get national recognition of marriage, would then cover spouses in all states. Those same rights and protections are not extended to unmarried partners, whether they be in a state-recognized partnership or not. So there's no employee benefit protections from there, which leads us into some of our discussions today about what the options are going forward. So I think it would be helpful at this point to maybe turn it over to Tanya to hear a little bit about the benefits that Darden offers for unmarried partners.
Yes, because we, Darden, operate in many different jurisdictions, we are not at the point, and I don't think we'll get there anytime soon, whereby we require employees to be married. So we will continue to offer same-sex domestic partner benefits. While we do have it written into our plan and do provide and recognize all marriages regardless of sex, we will not and are not prepared at this time to eliminate same-sex domestic partner benefits. We don't feel like we are at a point where we want to require our employees to go to a jurisdiction and get married.
And Bill, do you want to tell us a little bit about your company?
Well, sure. I'm pleased to do that. So a little bit about Dow Chemical, if you're not aware of it. We have annual sales of about $60 billion, do business in 160 countries, and have approximately 52,000 employees spread around the country, around the world, sorry. Our take has been a little different, I think, than a lot of major companies in that our benefit has always been, in regards to domestic partnership benefits, available to same-sex as well as opposite-sex couples. And that has been a long-standing, about 15 years now with the company. A lot of drivers for that, again, a global company, particularly a heavy footprint in Europe, where traditional marriage isn't as common as it once was, and people were looking more for other types of relationship status. That's one reason, and certainly with the LGBT component of that, and glad the gays, lesbians, and allies at Dow making a case that protection for our lesbian and gay employees. So for a long term now, it's been for both. Now, recently, in light of what's coming as a ruling, and if it's the way that we hope it is, you might consider doing away with those. It does incur cost for the company and is an additional burden as far as paperwork. But at this point, and for everything that we've been able to foresee, the statement was, let me just read it. Dow Chemical Company has offered domestic partner benefits. Has offered domestic partnership benefits to both gay and straight employees for about a decade, and the firm doesn't plan to change that, even if the Supreme Court rules in favor of gay marriage, because employees and job applicants are attracted to the benefit, says Johanna Soderstrom, Dow's Corporate Vice President of Human Resources and Corporate Aviation. So bottom line is that we expect to keep it, and we feel it's still an important part of our attract and retention policy.
Great. Bill, thank you so much for sharing. With that said, this is Daniel Lawrence Smith once again. We'd like to turn it over to you and hear about what's happening both for yourself and at your company. So we're going to go to another poll, and our first poll is, does your employer provide benefits for unmarried partners? The first answer is yes for same-sex unmarried partners, so it's or there was a character limit, so yes, same-sex unmarried partners. Yes, same-sex and opposite-sex unmarried partners. No, offer to spouses only, or I don't know. So go ahead and put in your results. We'll wait for a few more people to enter. We're at about halfway so far. We're at. Great. So we're seeing, once again, just a little bit in every category. So predominantly, yes, it's offered for both same and opposite sex unmarried partners. Great. Thank you all for your input. And then we've got another question. So has your employer indicated whether unmarried partner benefits will continue to be provided if same-sex marriage becomes legal nationwide? So first, yes to same-sex unmarried partners. Yes to same and opposite-sex unmarried partners. No, that it will be eliminated for unmarried partners. No, there are no current benefits to unmarried partners, or once again, I don't know. And if there's anything that falls outside of the spectrum, feel free to go ahead and put that in chat. Okay, we're about halfway through, if everyone can put through their answers. Okay, so a lot of people are not quite sure about where this is living. So that's a good question to have within your company. And we've got just one more question. This one relates to what sort of proof you need to put forward to show that you are in either a marriage or domestic partnership. The first is a copy of a partnership certificate, like a marriage certificate, domestic partnership, or civil union. The second is proof that you and your domestic partner or spouse live together. The third is proof of shared finances. More than one of the above, none, or once again, you're not quite sure. Okay, great. Again, we're seeing more than one of the above. We're seeing a lot of people that aren't quite sure. We're seeing a lot of certificates or partnership or marriage certificates. Thank you all for your input. Once again, I'm going to turn it over to Brian and Todd.
Thanks, Daniel. It's very interesting poll questions. I guess just a few quick comments on the results that came in. One, it seems like we've got a fairly vast majority of companies on the line that offer unmarried partner benefits to both same and opposite. And most of the research out there has shown that it's a very slight majority, so maybe we're a little skewed to a larger majority here, but that's helpful to see and kind of interesting. And then I guess on the third poll question, the fact that so many folks don't know what their companies are going to do in response to the decision means that we had a good idea here having this call, that's why we think this is an interesting issue to stay ahead of this issue and kind of plan ahead in anticipation of the ruling, because things are going to happen quickly and there's going to be, frankly, a lot of potential for knee-jerk reactions. So it's important to think through all the considerations, which is where we're going to turn the call to now, is talk about what companies ought to be thinking about, what are the considerations, assuming the Supreme Court decision comes out, as Brian said, favorable in favor of same-sex marriage in all 50 states, or at least in favor of recognition in all 50 states, which from a benefit plan perspective will effectively, in large part, mean the same thing. So let's kind of jump in there, and I think the key determination, a way to divide the world, if you will, in terms of what companies should consider, is whether the plan currently covers only same-sex unmarried partners, which again is a slight minority of plans, or if the plan covers same and opposite-sex unmarried, like Bill was saying that Dow Chemical does. So we'll start with the same-sex only plans. Here is the area where I think there's the most risk for, frankly, a knee-jerk reaction, and the most risk for a benefit takeaway is when a plan's domestic partner benefits program covers only same-sex unmarried partners. And within that group, there could be a variety of different categories and proof requirements. Some of these plans only cover registered domestic partners, state registered or city registered. Some will let you register by filling out an affidavit. As we saw, we're kind of all over the board on that issue. But let's kind of narrow the world to just same-sex only plans, meaning opposite-sex unmarried domestic partners, cohabitating heterosexual couples cannot be covered under the plan. This category of employers is I think the most interesting, because again, I think there's a potential for knee-jerk reaction, and frankly there have been a number of companies that have already announced that they're phasing out their same-sex unmarried partner benefits in anticipation of a ruling at the Supreme Court level, or in anticipation or in reaction to a decision in the state that they operate. So, Tanya mentioned being in all 50 states and how Darden reacts to that, but there are many companies that are in primarily in one state or primarily in a handful of states, and if those states have same-sex marriage legalized, many companies have already taken steps to eliminate domestic partner benefits in unmarried domestic partner benefits because people can get married. So to kind of go through some of the considerations, presuming a favorable decision in some fashion at the Supreme Court level, there'll be no barrier to same-sex marriage, or very, very little barrier to same-sex marriage recognition in 50 states. And that kind of poses the question to the employer, do we still need a mechanism to provide benefits to unmarried partners? So if you look at most of the companies in this situation where they're covering same-sex only couples, they put in these plans in the first place. If you dial back, 10, 15, 20 years when companies first started doing this, the whole reason companies put in the benefits in the first place was denial of access to marriage, that opposite-sex couples could freely marry in 50 states. Same-sex couples at that time, if you dial back a bunch of years, couldn't marry anywhere. So it was a pure sort of fairness issue and a way to provide benefits to couples that may be equally committed and in long-term relationships but have no ability to formalize their relationship. So now that they do have the ability to formalize their relationship, the crossroads is, do you require them to do that? And some companies have already made that decision and said, yes, we offer this benefit because of fairness and denial of the right to marry. Now that there's no denial of the right to marry, we want same-sex couples to get married just like opposite-sex couples have to in order to get their benefits. And the only issue for those companies is timing, meaning it's not necessarily fair to have marriage legalized in a state and then require somebody to get married tomorrow. Maybe it's important to give a grace period. And same thing with the Supreme Court decision. If it comes out favorably, say next week, probably not particularly fair to eliminate your unmarried partner benefits effective July 1st or even September, October 1st, but maybe it's a reasonably fair thing to do so as of January 1st or next open enrollment, which would be usually for most companies somewhere around the October timeframe in anticipation for a 1/1/2016 effective date. And that is what some companies are going to do. They're going to create a grace period. They're going to announce to employees that the purpose of these benefits was to protect you while you didn't have the right to marry. Now you do, and you have to get married by X date or you'll lose the benefits. You know, a couple things that get very tricky about this, one of which Bill already mentioned, is, you know, global employers. This gets very tricky because everything we're talking about here in anticipation of a decision and the Supreme Court ruling and what's happened in the States is solely a U.S. issue, that even if the U.S. works itself out here favorably in the next week or so, there are many employers that employ people in many countries that have not legalized same-sex marriage yet. So you do have to expand the conversation to global implications if you work for a company that has employees in multiple countries. That's one thing. A second thing is, you know, it's not, you know, this simple way to say it, but it's just not that simple. There's not a way to think about this without taking into account a sense of history and a sense of the emotions around it and a sense of what has taken us up to this point. So, you know, with respect to a new hire, for example, it may not be such a, you know, radical notion to change the benefit plan and say for new hires we're going to require same-sex couples to get married in order to obtain benefits. And if you come into the organization newly, because you're not used to having benefits, you need to be married to have the benefits. But with respect to current employees who've been covered under the plan for maybe, in some cases, 15, 20 years, and now are going to have benefits taken away, it's important to think through, you know, the emotional and historical considerations. There might be employees that have been in committed partnerships for 30 years and have made up their mind that they would never have the right to marry and they never thought they'd see it in their lifetime. And it can be quite a big thing for a company to say to an employee that, you know, we're going to ignore all that and say that despite what's happened up until this point, we're going to require marriage of you. And I don't want to suggest this only affects the older employees or the employees who've been in the long-term partnerships. You know, the same may be said about a 25-year-old who just thought they'd never see same-sex marriage in their lifetime. But I think it is a little bit more loaded when you think about all the people that this can touch and all the ways in which people may have made decisions up until this point. Even in some cases financial decisions, the way they've structured their estate plan, the way they've communicated with their family, the way they've paid lawyers and accountants to manage things a certain way, might all flip, and they may not, frankly, have any interest in getting married the same way that an opposite-sex couple may not have any interest in getting married, but their reasons may be more historically based or emotionally based, or things that are hard to quantify and hard to put one's finger on. So companies that are struggling with this issue, I think, are thinking through the idea that, hey, you know, this isn't as simple as you couldn't get married before, now you can, you have to get married. There may very well be more considerations out there from a human resources and people perspective that really create a very complex set of decision points for companies to consider, and really probably want to enter into dialogue with their employees about you know, this issue and what the implications would be, because it's just not that simple. In terms of the flip side of the equation, there is some thought, and I think frankly some legitimate thought that if employers do press ahead and do say, you know what, we are going to keep our benefits in place for same-sex partners only, there is a risk on the flip side of a reverse discrimination claim by heterosexual unmarried couples, because up until this point, there's been a very different categories of employees with respect to their unmarried partners. The same-sex unmarried employees couldn't get married in every state, and for the longest time until recently couldn't get their marriage recognized under federal law, whereas opposite-sex unmarried couples can. So any claim, say 5 years ago, by an opposite-sex heterosexual couple that would say, hey, you're offering benefits to same-sex unmarrieds and not to us, that we think that's sexual orientation discrimination or reverse discrimination, if you will, a claim like that never really had a chance in court, because in order to bring a valid discrimination claim, you have to be similarly situated. And those couples were not similarly situated in that the same-sex couples could not marry and the opposite-sex couples could. So there have been cases like this, both in state and federal court, on heterosexual couples suing companies for discrimination, but those have historically failed. What we face is if marriage is legal in all 50 states and the decision comes out how we think it comes out, suddenly the couples do look a lot more similarly situated. Outside of the emotional and historical considerations that I kind of walked through a minute ago, from a legal standpoint, if marriage is legal in all 50 states and marriage is recognized by the federal government, which it is now post-Windsor, there's not a whole lot of difference between same-sex unmarried couples and opposite-sex unmarried couples. And if a company is offering unmarried partners to one set, to the same-sex unmarried couples, and not to the opposite-sex unmarried couples, then it may very well be the case that there's a viable reverse discrimination claim there. And, you know, I hate to be cynical, although my experience tells me that that's the right approach for a lawyer to take, that especially around the area of lawsuits and plaintiffs' lawyers. I hate to be cynical about it, but I do think somebody's going to bring that claim, that there are going to be a set of employers that keep same-sex only unmarried partner benefits in place after the decision comes out, and they are going to face a reverse discrimination suit by the opposite-sex unmarrieds. And it's, I don't want to say that it's guaranteed to be successful, but it's a lot more likely to be successful now or post-Supreme Court case than it would have been when they were brought throughout the decade of 2000 range, when a few of these cases popped up and then were all pretty unsuccessful and then kind of faded away. So this is something to look for, and it is legitimate. I do think that companies that make the decision to eliminate their unmarried same-sex partner-only plans because they're afraid of one of these lawsuits, it's not necessarily a crazy thing to do or an unfair thing to do. I think it is one of the considerations that companies have to think through, and ultimately the courts will decide whether there's validity to that, but I do think that's something that potentially could come up. Moving on to the next slide, I think I'm going to turn attention to same-sex and opposite-sex partner plans. So like Bill was saying, the Dow Chemical type of plan where the plan, for any number of reasons, covers both same and opposite-sex unmarried partners. Here, there's less risk of benefits being phased out because there's already a group of employees being covered that has full access to the institution of marriage, and that's the opposite-sex unmarried. They can get married. They've had the right to get married all along, yet companies have decided to cover them, and in fact, a majority of companies that offer domestic partner benefits have covered them. The considerations here are a little bit different because of that, and I think there's less likelihood of a takeaway or a change in policy. Many employers simply don't want to legislate marriage to their employees and don't want to mandate that they have to get married, which is why they've covered opposite-sex partners. It's frankly a bit of a notion that we want to cover all types of families, shapes and sizes. We cover single moms, single dads. We cover two-parent nuclear families. We cover same-sex couples, unmarried and married. We cover people living with their elderly parent. We cover all sorts of families out there, and we're not going to change our mind now just because same-sex couples can legally marry in all 50 states. So many employers, I think, are going to stand pat, not do anything, but there is a sense that many companies that offer benefits to same and opposite sex unmarried partners didn't necessarily do so as willingly and as voluntarily as other ones. In other words, there's a sector of employers that when they first rolled out same-sex partner benefits, either because they had to under local, state, or local legislation like the San Francisco Equal Benefits Ordinance or certain domestic partnership laws that popped up in states, many companies, when they rolled out benefits for same-sex partners, did not want to necessarily put themselves on the cutting edge of LGBT diversity and necessarily make it an LGBT diversity issue for one reason or another, political, religious, any number of reasons. So as a way to depoliticize or take themselves out of the public eye a little bit on this issue, they rolled out benefits more broadly to same-sex and opposite-sex partners. So in some ways, for really diverse employers, I don't think this applies, but in certain areas of the country and certain types of employers, this definitely was an issue, that they didn't want to make it an LGBT issue per se and didn't want to be in the press for that because they were worried about what customers would think or what backlash might be, and they found themselves with same and unmarried on same-sex and opposite-sex unmarried partner benefits as a way to simply get the decision through and to not stand out in the crowd. So companies like that may wish to try to scale back unmarried partner benefits, but it's a lot harder to do that when you have same and opposite-sex couples both covered under the plan, because with respect to the opposite-sex couples, literally nothing has changed here, and nothing will change next week. So it's a lot more complicated in that regard, and I think companies are going to have a hard time pulling these benefits back, even though they are voluntary and legally they can pull them back. But I think we're going to see some deliberation and some decision points about this, but it's not going to be pretty from a public relations perspective if companies start cutting back on benefits in this regard, and I think there will be a lot of attention to that. On the flip side, if they were to try to do it, the way to point out, the considerations would be just how expensive and administratively burdensome unmarried partner benefits are. That spousal benefits are so much easier to provide because there's favorable tax treatment. There's not as many issues with respect to the proof process and the administrative process. So it's something that companies are going to have to think through, but it is legitimate to say that benefits offered to unmarried partners are very burdensome from an administration and certainly from a tax standpoint, both federal taxes in some cases and state taxes in many cases. And employers may say simply, we're tired of it and we want to get out of the business of offering benefits to unmarried partners and simply cover whomever gets married, particularly when marriage as an institution is open to everybody. So I think we will see some companies in this category getting rid of unmarried partners altogether and kind of hinging that to the idea that the administration is difficult and it's time to get out of that business. But it's a bit of a bigger takeaway and a bigger stretch when companies are covering same-sex and opposite-sex partnerships. I realize I've been doing a lot of the talking. Tanya and Bill, do you have anything to comment on or chime in on anything I've said to this point? I don't want to dominate the conversation here.
Well, this is Bill. I'll just make one comment about our policy, and it gets to your point about the added cost and also about your comment with the gross up. So at Dow, even though we had domestic partner benefits for both same-sex and opposite-sex, they were not grossed up for taxes. And so, as far as a cost savings and change post-SCOTUS decision, we don't have that particular cost still to incur because we've never had it. So it's really just the more manageable cost of managing a domestic partnership database and the insurance cost.
I don't really have anything additional to add. I think that one of the things that I know that we've had discussions here and that we will want to get in front of is as you said, as you mentioned, Todd, the reverse discrimination issue, and to the extent same-sex partners, become able to get married in every state and every jurisdiction, I think that we'll need to have some serious discussions, and we have had some preliminary discussions, and we decided at the outset we wouldn't make any changes. But I could see us looking at moving to an environment that mirrors Bill's environment. And we will definitely, our internal LGBT group is very vocal, as well as we have something called Daresters, which captures the younger generations, and they've had a lot of input and say on where they'd like things to land. So I think at the minimum there will be a lot of discussions prior to our making any universal decisions or changes with respect to the delivery of benefits.
Yeah.
Great. Thank you all so much. And at this point, I'd like to open it up for Q&A. We have a few questions that have already come in. So if anyone has additional questions, please go ahead and put them in the chat box, and I will bring them up to the panel. So the first one comes in, and the question is, have those companies who have stated plans to phase out domestic partner benefits in the event of marriage, that marriage is legalized nationally, mentioned plans to allow existing partnerships to be, quote-unquote, grandfathered in?
I'll, I guess, jump in first. I have not heard anybody really talking about grandfathering all that much, although I think, frankly, people haven't thought through this entirely yet. I have heard some talk about making the change with respect to new hires, which I guess is grandfathering in some sense, but I have not seen anybody do that. That's just one idea I've heard on the table and not actually seen implemented yet. At this point, I've only seen people pretty definitively come out on either side. So some have publicly stated, nope, we're not changing a thing, the marriage becomes legal, and then some say we are changing and will be eliminating benefits for unmarried, typically as of the first of the year is what I've seen most commonly, or it's already in place in reaction to a state marriage decision in one of the states that legalized marriage last year. But I do think grandfathering, I mean, it's a legitimate thought is, hey, if it is time for a policy change because the fairness issues line up a certain way and a company believes that, but they don't want to deal with the takeaway issue and they don't want to adversely impact some of the sectors of couples that, I referenced when I was talking about, what about somebody who's been together 30 years? And you really can't draw lines very easily and say, well, we're going to grandfather it for those folks who have been together 30 years, but we're not going to grandfather it for the 30-year-old who's only been together 2 years. It's pretty tough to draw those lines. So just grandfathering all existing partnerships that are enrolled as of a certain date is an option, and it's a pretty good option. It's a little administratively cumbersome, I suppose, but it's something that companies should think about. But I have not, personally, in my experience, seen anybody actually do that yet.
Great. Thank you so much. The next question, and we might not be able to answer it within this panel, but it pertains to insurance companies. So we know what a company might do, but will insurance policies then protect people who are in a domestic partnership, or will then that be termed only as marriage for those protections?
Yeah, I mean,
yeah, go ahead.
Go ahead, Brian. Oh, I was going to say, I think this is kind of a, like, almost the insurance company type questions we got at the very beginning of domestic partner benefits. Will companies write policies? Companies will write policies for almost anything that there are certain insurance company mandates that you have to, abide by. For example, if you're in a New York insurance contract, and New York, of course, recognizes same-sex marriage, so you will have to write your policy to cover same-sex spouses if you cover opposite-sex spouses, because that's what spouse means under New York law. But on something optional like this, on something where the company can decide whether they want to cover unmarried partners or not cover unmarried partners, I wouldn't think the insurance company is at any risk of saying, no, we will not write you a policy that covers domestic partners. I would think it'll still be very viable for an insurance plan to cover domestic partners, and insurers have been doing that for years, so I don't think they're going to stop now. But again, none of us work for an insurance company, so we'll see where that comes out. I'd be pretty surprised.
So our next one is not so much a question, more of a recommendation. And the recommendation comes that to allow at least 1 year of a grace period for those couples who want to get married on the anniversary of their civil union. So to allow a grace period for to enact a marriage moving from a domestic partnership or a civil union. And then the next question that comes in is pertaining to attraction and recruitment. So if companies think that it would be a good recruiting tool to offer domestic partner benefits, in the wake of the evolving landscape of what relationships look like, we see many opposite-sex couples that are choosing not to get married but still beginning a family and living together, and if that might be something that would be attractive to get new employees.
Yeah, I think I'd be interested to hear what Tanya and Bill have to say on that from the corporate standpoint, but I think that's a great point, and I think that's absolutely accurate. I think it was the last census that came out where it was the first time in history, I believe, that there are more unmarried households than there are married households in the U.S. So, I mean, terrific point in that, yes, the world is changing. A lot more people, opposite sex or same sex, are choosing not to get married just because they don't want to, or they want to live a different way, or any number of reasons, socio-political, all sorts of things. So from a recruiting standpoint, especially companies as large as Dow and Darden, every edge you can get to appeal to a more broad, diverse workforce, I think, is really helpful. So I think it's a terrific point.
Yeah, so this is Bill, and Brian, I think you've hit the nail right on the head, and that's our company standpoint entirely. We felt like it gave us a competitive edge, that it was attractive to particularly young people that we were interviewing. But I already mentioned too, outside the U.S. we've lagged a little bit behind. You mentioned the latest census, but in other parts of the world, it's already been going this way for a while. And so, when you combined everything, it just seemed like the company shouldn't be in the business of telling somebody you need to get married or not. It was, what can we offer you for whatever situation that you have that makes us an attractive employer.
I'll piggyback. I agree. The wrinkle for us starts with, our workforce is complex because we have so many employees. So 8 brands, 160,000 employees. So unfortunately, administration drives what we do a lot of times. I can say that while we absolutely have an eye towards retention, recruitment retention, we also are limited with respect to what we can do. So I could see us picking, a program that would be easy to administer, and that would be setting us up for success. So while we do tend to be liberal and very generous with our benefits, I do not see us going towards a system that will require manual processing or anything to that nature. It would have to be streamlined in order to execute and deliver.
Great. With that said, I'd like to open it up to the panel for closing comments. Once again, we'll go left to right, beginning with Todd.
Sure. Thanks. I guess we've jumped a little step ahead in this regard. I think it's always good to stay ahead and be on the cutting edge. But let me first take a step back and say I hope we have this problem, if you will, to deal with, and that I hope the Supreme Court comes out as we're predicting. We're not prognosticators. You can't ever guess what the Supreme Court's going to do, but I sure hope we have this problem. If this is the biggest problem with respect to same-sex partnership benefits, we'd be in by far the best place that we've been in since I started working on the issue back in the late 90s. So that would be a great place to be, and a minor problem to have, to sort of communicate to companies the complex reasons behind not wanting to scrap benefits too quickly. The other thing that I think will be interesting is just to see this reverse discrimination issue is an important one to keep an eye on, because I think there's going to be a real push amongst advocacy groups, certainly like Out and Equal and other folks like everybody on the phone and LGBT affinity groups, to get companies to keep their benefits in place. But this reverse discrimination one is a real threat to that. So I hope plaintiffs, lawyers, and plaintiffs are not too aggressive about this, and that it doesn't come up too quickly, because I could see that really scaring some people off. And as a lawyer, and frankly as a reasonably conservative, I do really worry about it from a legal standpoint, that from a discrimination case law standpoint, the way these cases work and the way courts are likely to view plaintiffs as being similarly situated, I do think there's a concern there, and that's something to just keep eyes on as this unfolds. But hopefully we have this issue. Hopefully the news is nothing but good come presumably next week when the Supreme Court rules. And like I said, if this is the biggest hurdle to overcome, I'm sure most folks would take that, given where things have come from and how much harder it used to be to get companies to focus on these issues at all. So the news is mostly great. It's just staying ahead of a fairly complex issue and thinking through it before anybody takes knee-jerk reactions and stuff spreads like wildfire in the media about companies, changing their benefits, which has the potential, if people don't think through all the consequences. So I'm glad everybody could join in, and thank you all for your great questions.
Thank you, Todd. Brian?
Just to echo what Todd said, and again, thank you, Daniel, and Out and Equal. I saw a few comments about questions about whether the slides and materials will be available. Certainly, we're happy to share that, and to the extent that we can provide other resources, or there's questions as you're looking at these issues and having internal discussions about those, please feel free to reach out to us. We're happy to share resources and be of assistance with that.
Thank you. Tanya?
Yes, I think I'd, again, echo what Todd said. I think that, or hopefully this will be a good problem that we'll all be facing. And from our position, and I'm sure many of the individuals representing corporations on the line, I think that we will probably take a step back before we make a decision, but feel really confident as we're moving forward. And we have fully insured arrangements. We've got a complex benefit structure. We want to do the right thing by our employees. I'm excited. I cannot guess where the Supreme Court will come out at, and have not been successful in the past. So we'll wait here over the next 2 weeks and see what happens. Everyone.
Thank you, Tanya. And Bill?
Well, again, thanks for the opportunity to talk today. I think it was a really good discussion. To echo what Todd said, I'm hoping you can never know what the Supreme Court might do, but they were worried about getting too far ahead of public opinion, and I'll just offer this out that I live in Indianapolis, and we celebrated our Pride. Everybody knows what Indiana went through earlier this year, and we had over 100,000 people attend our Pride. That's 1 in 7 people in the city. I think society is ready to go along with same-sex marriage and different ways of looking at relationships.
Thank you. And thank you to all of our panelists for sharing today, for taking your time and giving your insight. We're certainly all very hopeful of how the Supreme Court will rule at the end of the month, so we're going to think very positively about that. We have a few announcements from Out and Equal. On June 22nd, we're going to have part 3 of our Train the Trainer workshop series. On July 23rd, we're going to be in Orlando with our partners at the Walt Disney Company for an LGBT Workplace Equality Institute. You can go ahead and follow that link for more information. July 30th will be our next monthly town call, and then August 27th will be our August town call. And then, of course, October 5th through 8th will be our 17th annual Out and Equal Workplace Summit in Dallas, Texas. And our early bird registration will end on July 31st. So go ahead and get registered. We hope that you will join us and 2,500 of your closest friends in the great city of Dallas, Texas for what will be a fantastic Out and Equal Workplace Summit. On behalf of Out and Equal Workplace Advocates, I would like to wish each and every one of you a very happy and safe Pride Month. And at the end of this call, there will be a brief survey. Please go ahead and fill that out. We're interested to hear about your experience and, of course, get feedback on what we can do to make this a better experience for each and every one of you. Thank you all so much for your time, and have a great day.